Realization. We're going to record. And I found this picture. Hold on. Can you see it?
Oh, cool.
So that was 2018 or 2019. I think it was 2018. It's 2018.
You're going to have to send me that. That's amazing.
Isn't that funny? So that's where we were 6 years ago. And so that is to set up where we are now. Take it away.
Yeah, well, thank you for those who are tuning in. The other people on that you'll be hearing from, David Israelite, who is the head of NMPA, National Music Publishers Association. He's our main guy who goes to Congress and slaps people around, and then goes to DSPs and slaps those people around. Michelle Lewis, if you guys don't know, she runs SONA. She is behind David slapping people around. And then I'm a guy who also likes to make noise and pick fights that are winnable. And I think what's exciting about this conversation is that for years we've been in a battle. You could argue a war with the DSPs as we've been defining what streaming royalties are, and we had some major victories in the last year, and David will explain that sort of where we started and where we're at currently, and it's almost a recap of how the war was fought and in a way how the war was won, and we can talk about all the ways that we can move forward and also, you know, open the community to questions. So David, take it away. Michelle, do what you do, and I'll just listen.
Great. Well, thank you so much. Hopefully, we're going to be doing a lot more handshaking and a lot less slapping going forward. And really pleased to be able to talk to you all about where we are with the Copyright Royalty Board and songwriter rates. And so we thought this was a good time to have this conversation because there's a lot of moving parts, but we're also at an inflection point where we have a really big settlement that we've entered into that is not yet final, but it's at the stage we should be talking about it, and you should understand what's going on with it. First and foremost, for songwriters, which I know that this audience is mostly songwriters, and I see some other friends in the room as well, which they're welcome, is that you're just so lucky to have advocates like Michelle and Sona and Ross with everything that he does, fighting on your behalf. It's really a pleasure to work with them as partners on these issues that affect us all in terms of how we get paid from digital music companies. And I don't think we would have the successes that we're going to be talking about if it weren't for the organizing and communication and advocacy of people like Michelle and Ross. They were a large part as to why the digital music companies decided to enter into a settlement that's so favorable to songwriters. And so I just can't thank them enough, and just want you to know how lucky you are to have them in your corner. I'm going to go through a couple of slides that I used in talking to the music publishing members of NMPA, and just going to really use the same slides here. Let me make sure I get this over here so that everyone can see it. And I think I've done this right. To kind of update you on where we are, in particular on the Copyright Royalty Board and our rates, although I understand that we're going to allow questions as well. Yes. You can't see it anymore? Okay, let me see if I can get it to work for you now. Let's see if that works better.
And just ask the questions in the Q&A section. I'll send them forward to David.
That work? Okay, I'm told that you can now see the screen. If that's not true, let me know. And so, yeah, happy to answer questions about anything I present here, and also anything else that you'd like to ask about. We'll make these slides available so everyone can have a copy, so don't feel like you need to take notes from them. And I know we're going to record this session, so anyone who's missing it will have a chance to listen to it later. So the way I think about this story is kind of in chapters, and we go back in history because it's important to understand where we came from to understand where we are. And the first chapter in this was really how we went about setting up how digital streaming companies pay songwriters and music publishers. And I think a lot of people forget that it was not always agreed upon that digital music companies like Spotify or Apple Music or Amazon Music would pay a mechanical royalty to songwriters. That's something that we now probably take for granted, but in the early days of streaming, that was not settled at all. And so the first chapter of the story really goes back to the year 2000 through 2007, where we had to establish the rights that we had in this model. And so songwriters are well aware that the old model kind of involved selling copies of music, which were our mechanicals, whether it was vinyl or a CD or a download, or having radio type models that paid us a public performance. And so when interactive streaming companies came about, there was a real question as to what they were. Were they a mechanical reproduction like a sale? Were they a public performance like a radio transmission? And it turns out that they were both. And we agreed that they would be both, and they would pay both a mechanical and a performance. But the mechanical part is the part that is regulated by law and where the rates are set by the Copyright Royalty Board, 3 judges that sit in Washington, D.C. And every 5 years, they have a trial. And so from the very beginning of this business model, we had to fight to make sure that you were paid both a mechanical and a performance. And that was something that we were able to do in that first chapter of this story of the years 2000 to 2007. The second chapter is that once we've agreed on the structure, we had to agree on how much they would pay us. And for the first 10 years of interactive streaming models, we and the companies that did these models agreed on what they would pay. And they were largely experimental. There wasn't a lot of money in these models. We were still mostly an industry that focused on sales, whether they were downloads or CDs, some vinyl. But we were able to agree on a structure where digital music companies would pay us an all-in rate, and that would comprise both the mechanical and then the performance part of it as well. And so for that first 10-year period, we came to an agreement. We never had to go to trial against the digital streaming companies. We had an agreed upon rate structure, and that agreement basically lasted for 10 years, from 2008 to 2017. What happened next was then when we got to the year of 2018, these models were now commercially very significant. There was a lot of money that was involved. There were major players that were in this space that were not there before, that were doing streaming models like Spotify, like Amazon, like Apple. And when we got to the trial for this third period, which we call CRB3, we could no longer agree on the rates. And so what happened is in 2017, we litigated in front of the Copyright Royalty Board what the rate should be for this 5-year period. And NMPA was on one side of the courtroom representing all the publishers and songwriters. And you had 5 giant digital companies on the other side of the courtroom: Apple, Amazon, Spotify, Google, and Pandora. And we went through a year-long trial. It was very expensive. It was very nasty. And at the end of that trial, we got a decision in January of 2018, and we won a major victory. The Copyright Royalty Board agreed to give songwriters their first real pay raise in more than a generation. And they ordered that our rates should go up by more than 44% and increased what was known as the headline rate, which is how most people think of the rate structure, from 10.5% of their revenue all the way up to 15.1% of their revenue. And 4 of the 5 digital companies decided they were not going to accept that decision. And they appealed that decision to a federal appellate court. And we have been in that process ever since. And here we are sitting today in mid-November of the 5th year of the 5-year period of 2018 through 2022. And we are still not done with the process that sets the rates going backward 5 years. And I'll explain exactly where we are and when you can expect that money. But the bottom line is that we couldn't agree. We went to trial, we won a big victory, And then we've been fighting to protect that victory ever since. Now, at the same time that we were battling these giant streaming companies in the Copyright Royalty Board, we also came together to fix how we license music procedurally by passing the Music Modernization Act. And the Music Modernization Act, or the MMA, basically is what set up the new Mechanical Licensing Collective, or MLC, that is now responsible for collecting the money and distributing the money to songwriters. And there were a lot of really great things for songwriters in the MMA. When we created the MLC, we did so where we no longer pay any commission on mechanicals. The digital companies fund the MLC completely. You get 100% of the mechanicals without anything coming off the top. It's the only society in the world where that's true. You now have a transparent and public database, which never existed before. We now have an audit right, which we never had before that. And so a lot of great things came out of the MLC. And so we were working together to create the MLC while we were fighting with each other over how much money they would put through the MLC, which created this kind of very weird dynamic of we were partners in one hand and we were fighting with each other on the other hand. But what happened then when we got to this next CRB period that we call CRB 4, which is for the next 5 years, starting in 2023, is that on the eve of the trial, where we were going to go back to court in front of the CRB and fight with each other over the rates, we came to a historical settlement with the digital music companies. So in addition to winning the appeal of the last decision, which took us 5 years to protect, we now have agreed on what we should get paid going forward. And that agreement is really good for songwriters. And so that agreement currently is sitting in front of the court. There is a public comment period where anyone can weigh in with public comments. And then ultimately, we hope that that agreement will be adopted and we will be ready to pay the new rates out starting in the next year in 2023. Now, what that settlement involved, first of all, the highest rate in the history of interactive streaming in the world. Our rate is now going to step up to 15.35% of revenue of these services. Secondly, the alternate structure of how the rate gets set, which is a complicated kind of three-pronged test where we get to ask 3 different questions, and then we get to take the highest number that comes out of the 3 different questions. Those second and third tier numbers also are going up. So if the first question is, how much is 15.3% of your revenue? The second question is, how much did you pay record labels? And we get a guaranteed percent of that. And the third question is, how many subscribers do you have? And we get a guaranteed amount per subscriber. But the bottom line is, under this new agreement, we expect the first prong, the percentage of revenue, to likely be the prong that wins out in terms of the 3-part test. And we expect those rates to go even higher, because remember, when we're getting paid a percentage of revenue, we are now partners with the digital companies where the more money they make, the more money we make. And we can make more money in lots of different ways. For example, when they add more customers, that's more revenue that comes in, we get a percent of that revenue. When they increase prices, as Apple just did, we now get a percentage of a bigger revenue pool. So we are now tied together in getting a historically high percent of their revenue and now working together to increase that revenue pool over the next 5 years. So it's a really fantastic settlement. We avoid the trial altogether, and it opens up all kinds of other possibilities in terms of how we can work together so that we can be partners instead of enemies in these CRB proceedings. There's a lot to like about this settlement. As I mentioned, it's not quite final, but we expect it to be final very soon. So let me give you a couple of other facts about how this is going to work. Looking backward for the years 2018 to through 2022, we think that as an industry, we were underpaid about $600 to $700 million. The reason we were underpaid is because during the appeal of the last decision, they were paying us like it was 2017 under the old rate structure. Now that we've won on appeal and we know that we're owed the higher rate structure, that's retroactive. It goes back to January of 2018, which means that once the decision from CRB 3 is final, they then have 6 months to go backward, redo all of the accounting, and pay us the money that we're owed, which we estimate, again, between $600 and $700 million. Because of how that process plays out, you can expect to see that money probably not until the second half of next year. It's a legal process. It has to get published. It has to get approved. And then ultimately they have 6 months to pay it. So second half of 2023, we're expecting an infusion of up to $700 million that we are owed for the past that will then be distributed out through the system. Looking forward, we're going to get paid that higher rate immediately and throughout the next 5 years, which means you're going to see a spike in what you get paid from companies like Spotify, Apple, and Amazon because of the higher rate structure that will kick in immediately, which is even better than the one that we now won on appeal from the last term. So it's a really positive story for the industry. We think that we're optimistic about what that means for the overall health of songwriting and music publishing. And we're very happy about the fact that, to Ross's and Michelle's point, not a lot of slapping that's going to be going on, but rather more handshakes in terms of how we work together. So we wanted to brief you on where we are in terms of that process. The public comment period is open for another couple weeks. Organizations like SONA, like NMPA, are all going to be filing comments to the CRB. And then once that's final, we'll let the community know. But the good news is historically high settlement. And again, thanks largely to the effort of great writer advocates like SONA and like what Ross does. And we thank you for that. And so that's the update. I hope it was clear, but happy to answer questions about it or about anything else that you'd like to ask about. And I think, Michelle, you're going to take the lead at kind of filtering through the Q&A and then posing the questions that we can all comment on if that works.
Yes. Thank you, David. That was really clear. Although, it's a lot. There's a lot of acronyms. So I just want to also invite our watchers to, if you need clarity on any of the acronyms or anything like that, the questions can be that granular, right? We are here to really clarify. So don't worry about, any kind of question being too high level or anything like that. Ask away. So one question is, not sure if this could be answered by David, but actually I think it can. As a Canadian songwriter working both in Canada and in the US, I'm wondering if there's any sense of how these advances in the US might affect royalty payouts in Canada. And if that's, and we've talked about this.
Yeah, no, that's a great question. So as I think every country has their own rate structure and a different process by which the rates get set. But the United States has often been looked to as the benchmark of where the rates will get set in the rest of the world. So when we were negotiating this settlement with the digital companies, they were modeling the settlement over what it would cost them if the rates that we agreed to were applied broader than just the United States, because the expectation is that once you set this benchmark in the United States, that in other countries, you would expect there to be an effort to get those countries' rates up to where we are in the United States. There's no guarantee that's how it would happen. In Canada, as I think you have your own royalty process, which is fairly convoluted and challenging for songwriters. But the hope is that we won't fight as much in other countries because the benchmark's been agreed to, and that's where the rates will get to. And we hope that will be true for Europe, for other large music markets like Japan, Australia, et cetera, and especially for Canada, where there's such a close link between the music markets of the United States and Canada. So no guarantee, but definitely a hope that this will help bootstrap the rates up in Canada.
Awesome. This is not in the Q&A, but it's come up in other conversations that we've had with songwriters and other songwriter groups. We're talking about what the comments to the CRB judges are going to be and what they're going to be asking for on behalf of songwriter groups. An acronym that comes up a lot is COLA, COLA, the cost of living increase. Can you, so that's what a lot of songwriter groups are at, or want to ask about, or maybe advocate for with the judges. Can you talk about that a little bit?
Sure. It's a great question, and I'll try to make it so that it's not confusing. I hope I can. So the way that mechanical royalties used to work was that it was only really about physical product when you would buy a copy of something, and there was a penny rate attached to it. And for a very long time, the 9.1 cent rate was the rate when you would purchase a physical product or when you would buy a permanent digital download like on Apple. And there was a lot of frustration that that 9.1 cents didn't go up over time, even though inflation made 9.1 cents worth less year over year. So one of the settlements that is part of this overall complex is that we settle with record labels over what we're going to get paid for physical product in the future. Now, it is a significantly smaller part of the economic pie than it used to be, but it's still very important and valuable. And for some writers in particular, it's more valuable because of the type of music they make. The agreement we have with the record labels as part of the same settlement structure is the 9.1 cents is going to go to 12 cents. So it's going to jump up to 12 cents, but then it's also going to continue to be adjusted by what's known as a consumer price index, or some people call it a COLA, cost of living increase. And so what the CPI index does is every year there is a specific government controlled process of determining an inflation rate, and that 12-cent number will go higher every year over the 5-year period. We don't know how high it will go because every year the adjustment is different depending on the inflation rate. It's technically known as the CPI-U index, which stands for Consumer Price Index Urban, which measures the prices of several things and then ties it to those increasing prices. So 12 cents may go to 12, 1 cent, 12, 5 cent, 13 cent over the 5-year period. So major win that not only did we get an increase in the 9.1 cent to 12 cent, but that 12 cent number will also grow over the 5 years because of a COLA that's attached to it. Now with the streaming services, it is a different way we get paid. We are not getting paid a penny rate. We are getting paid a percentage of their revenue. So when we're getting 15.35% of their revenue, there is no COLA built into that, because the assumption is if they raise prices, we'll get a bigger number because we get a percent of that revenue. So for example, when Apple just announced that they were raising prices and they blamed our agreement as the reason why, which is just fantastic. They're saying that it costs more now to pay for the music, so we're increasing the price to the consumer. Our take of that money goes up because it's a percent of revenue. You don't have COLAs or CPI indexing attached to percentages of revenue. But in the other parts of the rate structure that are penny-based, for example, when we go from 50 cents per subscriber to 60 cents per subscriber is one of the prongs, there is also not a COLA tied to that. The reason why is because we negotiated the full increase up front. So for example, we could have negotiated potentially 50 cents per subscriber with a CPI index. But instead of that, we were able to get 60 cents per subscriber immediately, which is actually a better jump than the anticipated CPI increases. So it all depends on where you come out a winner. But the bottom line is what we tried to do in these settlements is make sure that songwriters come out the best. For physical product, that meant a jump in the rate with a CPI index. For digital streaming, it meant a percentage of revenue increase and a jump in the number for the full 5 years. And that turned out to be better than a CPI adjustment. Now, in 5 years from now, we do this all again, which means that if inflation is going up higher than the jumps we've negotiated, we might take a different approach next time. But for the next 5 years, the songwriter community has come out the best by having COLA on physical product, but percentages of revenue and big jumps in the number on the digital side. And that's why it's the settlement that we agreed to.
Okay. So, but if like Spotify decides not to raise its rates, there's no kind of accountability for that. Like they might not keep up.
That's right. So when we are tied to a percentage of revenue, as I mentioned earlier, there are a couple of different ways we can win. One way is they have more people paying into the pot, so more subscribers. The other way is if they raise prices, and they can raise prices on their subscription price, or they can do a better job of collecting advertising revenue if it's a model based on ads like Spotify, free to the consumer. The reason why you cannot get a COLA attached to a percent of revenue is because then you could get, in effect, the best of both worlds, where their revenue pool may be getting bigger, so we're getting more money, but then we're also getting a higher percentage. They'll never agree to that. The percentage jumps are based on the situation we have right now. You're never going to get the percentage number to go up the same way you get a fixed number like a penny rate to go up. And again, where we do have a fixed rate, like on a per subscriber number, we did better than a CPI index. We did better than a COLA because we were able to jump the number more than the projected inflation increases. And we were able to do it in year one and apply it to all 5 years. And that's why our settlement, I feel very strongly, is better than if we had gotten a COLA on that part of the settlement.
Okay. Okay, hopefully that answers. Let's go to another question. Does this affect artist royalty payments in these platforms?
Yeah, and I think we forget sometimes that, it gets very confusing when you're talking about all these different types of royalties. So Spotify, just take a simple example, has to pay for two different things. One, for the sound recording, so it's the artist and label, and then separate from that, the songwriter and the music publisher. What the record label and artists get paid is not part of this. Record labels and artists have the advantage of being in a completely free market. There's no government regulation over setting their prices. They sit in a negotiating room and they agree on a price. And so when our prices go up, it does not affect the artist or the label side. And unfortunately for us, we're in a system where we don't get to negotiate our prices in a free market. We have this government set rate with a 3-judge panel, and we get what the court tells us, or we settle. Now, a lot of people argue it's just one pie. There's only so much to go around, and that's true. So for every dollar, some of it goes to the digital company, some of it goes to the label and artist, and some of it goes to the songwriter and publisher. But the difference is everybody else is negotiating what comes out of that. For the songwriters, we're told what we get out of that through this process at the CRB. So this doesn't affect artists and record labels. But to be fair, I think we should be in the same system. And I'm one that believes that songs have equal value to sound recordings. But you're not able to do that in this process. All you can do is kind of make incremental increases. And we've done that here, which I'm really happy about. And I know, Ross, you've thought a lot about this question too, about the value of the song versus the value of the artist's rendering of the song. And, I'm sure your opinion is, more real than mine as someone who actually makes the great songs.
Yeah, I have a few opinions about all of it, as you can imagine. And I know we've discussed this before, and so I don't want to go on a giant tangent and take away from what we're talking about. But as a publisher and an advocate, I feel like part of my job when I'm wearing those hats is managing expectations and making sure songwriters are honest about where they are and what they're doing. And there's some things that keep sticking in my head. I was speaking to somebody who runs a major publishing company who said eloquently that just because you write music doesn't mean you're entitled to make money. And that's really difficult for songwriters to acknowledge, that just because you release music doesn't mean you're entitled to make money. You can't necessarily control how the public receives the songs that you write. You can try to influence that. The label's job is to help influence that. But it doesn't mean that just because you release music that therefore you should get paid more. Just because if you have 1 million streams and there's another one that's 1 billion, no matter how mad you are at DSPs for whatever they're paying, no matter how mad you are at your publisher for getting whatever percentage, no one owes you any money. You have to write songs that have impact on the community at large for you to receive any money in return for your work. So I think it's just important that as we're talking about all this stuff, that encouraging songwriters to keep diving into what makes a great song, trying to put out your best material, and keep up with the fact that this is a world where there are too many songs and not enough hits. There are a lot of people releasing a lot more music. It's much harder for artists to be successful right now because all the algorithms are about it's really advantageous to be a user of one of these platforms than it is to be a content creator. Their job is to have you sift through as many songs as possible. It's not to dive further into your artistry if you are an artist in this case. But as a songwriter, your job is to try to be relentless in creating quality content as much as you can, so you can try to receive some of the benefits that we're fighting for. But just because these numbers go up, that doesn't mean that there's nobody who's going to pay you. This gets into a whole other issue that we can talk about later, and where I think we can go to making sure that we ensure that there's money for people who are releasing some music, at least on major labels. But in the meantime, I just want to clarify that what we're talking about is percentage of music, of songs, not that are released, but of songs that are generating income. So yes, your song that may have 100,000 streams, that's going to be a nominal amount of money, and it will increase to 15.1%, give or take, of the overall pie from that
Right.
that song. But it's not, it isn't going to all of a sudden pay your rent. And that's just something, no matter what we do, that is not what we do as advocates. What we're trying to do is move the entire industry forward. And what your job as a songwriter is to write songs that impact an audience and touches many people, so that way you can actually receive the benefits of what we're doing. So I'm sorry, that's a long conversation, like a long tangent,
Well,
but I
but
always
it
just
does.
think about it, and I think it's important.
It is important, of course, because we realize with anything in the technology economy and the tech economy is that it rewards scale, right? Like for authors, for journalists, no, if you're at the top percentage, if you have market share, you get paid. But if you're sort of in the, anywhere in sort of the middle class or starting out, there's not a lot there for you. That's what we seek to sort of try and find um, workarounds for. But what you're talking about is right, and it leads into a question that I hear a lot that I want to ask you, David, which is that I hear this all the time, and it's sort of it's like it's one of those questions that is not the right question, but I hear it a lot, which is what service pays the best,
Sure.
right?
Um, one of the things that has been frustrating in this entire process is that when we were fighting over how much we should get paid, it's a compulsory rate. It's set by law. It's the same for everyone. So it's not a case of where you have one company paying a vastly different amount than another company. They're all paying the same structure. But what an individual songwriter gets paid can vary quite a bit because it's based on how many streams there are from that service. So for example, if Spotify has $1 to pay out and Apple has $1 to pay out, it doesn't mean that if you have the same amount of streams on both services, you get the exact same amount of money, because that dollar on Spotify is divided among all the people that are listened to on Spotify. And the same thing's true for Apple. So the volume of streams can affect the rate. Now, one thing we know is true, the advertising-based models like Spotify free to the consumer pay significantly worse than the paid subscription models. So we're big fans of when consumers pay for their subscription like they do with Spotify, Apple, Amazon, more than when it's a model where it's free. And we as songwriters and publishers have no say over that because we don't get to to turn that off if we don't like the model. But there's not a significant difference over what they pay other than what varies every month about the amount of streaming. And so, we don't like to call out any one company as being better than another company if they're all basically paying about the same. And under this settlement, they've all agreed to pay us more, which is what's so great, because for it to be a settlement, we all had to agree, which means every one of the digital media companies that were litigating this case agreed on the new rate structure. And so that's fair.
That's a great point, and I want to take a minute to shout out the person on the other side who had to herd the cats on the digital services side, Garrett Levin, who had to deal with the very different business models between Apple, Spotify, Amazon, and get them to agree to one thing. I mean, think about, the different agendas that each of those companies, the different models that each of those have.
It's a great point, Michelle, because one of the things that's true is that they all have different models and there's different things they care about. So for example, it's clear that Amazon's music strategy is largely tied with what they're doing with their Prime product. Spotify's music strategy, where they're the only one that really has a free service to the consumer, and they're also trying to expand into podcasting and things like that, has a different focus, and they're a music-only company. They're not part of a giant technology company that sells phones or subscriptions to Prime, as the case may be. Google, which does participate in this, but it's mostly outside of this world because they have video involved in YouTube. And so the video part of YouTube is separate, but part of what they do qualifies for the mechanical license. And so we had to bring all these companies together and agree on a structure that worked for all of them. And you're exactly right. Garrett Levin at the Digital Media Association did a great job getting his members together to have this conversation with us. And it really is an important moment in the history of the industry, because for 7 years, we've been at war with each other, figuratively. And now we feel like we can kind of turn the page and figure out how we can make more money together for songwriters, which is a really great place to be.
Right. It's sort of more of a conversation than an argument.
Yeah.
Which is important. Dana Childs, hi Dana. She said, so this is also a very kind of like concrete question, right? That we are talking about sort of the formula that goes into payment, but what does that equal? She said, is it possible to approximate real world dollars in relation to streaming milestones? So what, right? Like that's another question I get a lot. What is 1 million streams worth?
Yeah. It's a great question. And we look at it a couple of different ways. I mean, we look at the whole industry in terms of dollars and what this means. And then for individual writers, you obviously look at, what does it mean to me if I have 1 million streams or, a #1 song or the case may be. And it's a moving target all the time, because month to month, this number changes depending on, again, the revenue pool and how many streams there are. And then how much per stream, and then you can run the formula about 1 million streams or things like that. But there are a couple of, I think, key evidence points, and I'm actually going to grab a document that's going to tell you some things about this, which I'd love to share. So, we collect a lot of revenue data, and we do a lot of analysis about the industry. And one of the things that I think is really interesting is that if we look back at 2021, which now seems pretty old, that we're 11 months into 2022, but just looking back at the year of 2021, one of the things that really jumped out to us is that these interactive streaming models are now by far the largest revenue source in the industry. So compared to any other way that songwriters get paid, whether it's radio or television or physical product or synchronization placements, interactive streaming dominates the revenue stream in terms of what comes in, and it's only growing. It's only becoming more important. And I saw one of the questions earlier that raises a good point. You're getting this money through two different pipes. You're getting it through your PRO, which is reporting to you the performance part of what happens, and you're getting it through your publisher, or if you're self-published, you're getting it yourself. The mechanical part, you've got to add those things together to know what you're getting paid from a Spotify. And it's hard to do because your statements don't line up in the same time period necessarily, and it's not always crystal clear. But if you're trying to figure out how much did I get paid for having my music on Spotify, you need to add together your PRO statement with your publisher statement for mechanical. We know that looking forward, our deal that we've made is projected to probably pay out in our industry of songwriting and publishing somewhere north of $15 billion over the next 5 years. And I think this is maybe the most important statistic that I've seen in this entire conversation. More than 75% of that money goes to songwriters. It is a very different model than the label artist side, about when a label collects $1, how much goes to the artist. When a publisher collects $1 from an Apple Music, an Amazon Music, a Spotify Music, more than 75 cents of it goes to songwriters. And so this conversation is mostly about songwriter pay, not publisher pay. And so the increases are most important to songwriters. And we can do very specific formulas about what 1 million streams are worth or how much every service pays. And we're actually going to be producing a product on a month-to-month basis based on data that we get from the MLC that we are waiting to put out until they start paying us the proper rate. So it will probably be in a couple of months, but check back on the NMPA website because we are going to start publicizing every month what these services pay for 1 million streams. But we don't want to do that until they're paying us under the new settlement formula, which is fair to them, because right now they're still paying us like it's 2017. And that's a wildly inaccurate way to look at how much we are owed.
I see there's a lot of questions that we've kind of answered in the Q&A, not live, but they're relating to the MLC. So, and when we're talking about this particular increase, we are talking about money that is on that right? The non-interactive digital streaming mechanical, not the performance. We're talking about the right that is paid through the MLC. So can you talk a little bit about the way the MLC processes this, right, and how it will pay out?
Sure. And it gets really complicated, and I appreciate that. And some of the complications actually for our benefit, it's to protect us. But that doesn't change the fact that it's complicated. So let me try to make this really simple. When I say the rate is 15.35% of their revenue, that's an all-in number. That's what they owe to songwriters and publishers in total. The way that it works is that if they owe, let's just make it simple, 15.35% of their revenue, at the end of the month, they calculate their revenue, they multiply that by 15.35%. What they then do is say, how much did we pay the PROs, ASCAP, BMI, CSAC, GMR? And then we deduct that from this total number, and the rest of it goes to the MLC. So back when the rate was 10.5%, that split was about 51% went to the MLC and about 49% went through the PROs. So if you were a songwriter and you got $1 from Spotify, you were getting 51 cents basically through the mechanical pipe, 49 cents through the performance pipe. When the rate goes up, that ratio is going to start to shift to be a little heavier mechanical and a little less performance. But that can always change because the PROs can change what their rates are potentially, and that can affect it as well. But just understand that it's an all-in number. And what they technically get to do is like a tax deduction almost. They say, what did we pay the PROs? And then what do we owe in total? And the rest of it goes to mechanical. And that's basically how the formula works. And look, there are advantages and disadvantages about which pipe it comes through. Like, I mean, sometimes I talk about things that are a little sensitive and people get a little uneasy, but I just like to be blunt and straightforward. For some songwriters, they like the money coming through performance better because there's no recoupment of an advance from a publisher. Now, they may have an advance from a PRO that they have to get recouped, but the idea is it's directly from their PRO, no recoup. And so I kind of like the performance pipe better. But on the mechanical side, we now have an MLC that takes no commission, which means that you're getting $1 for every dollar that you're owed. Whereas on the PRO pipes, they're taking overhead costs off the top, which can, range depending on which PRO. And so there's an advantage on that pipe as well. So it can be a mixed bag, but the bottom line is you want the protection of having it be both, because you're getting more money as a songwriter by getting 2 different payments for the same activity. And the truth of the matter is, record labels don't care what you call it. It's just them negotiating the value of their copyright, collecting the money. We have to care what we call it, because our mechanical is regulated by law. Our performances are mostly regulated by consent decrees, which means what we call it or what it is affects how the rate gets set, unlike for record labels where they just negotiate a rate. And so, yes, it would be a better world if it were like a synchronization, where we're just in a free market, we negotiate the value of it, we charge it, we collect it, we pay it out. But because of the complicated history of songwriting, it matters which pipe it comes through and how we characterize it. But the good news is we're partners on all of this. Publishers, PROs, songwriters, we all have the same interest: maximizing the amount of money that goes into the songwriter pocket.
Right. So you're saying it's 6 to 1?
Well, again, it can make a difference. If you're a writer that has a large publisher advance that's unrecouped, you might say, I really like it better when it comes to a performance pipe. If you're a writer that's self-published, or you don't have an advance that's unrecouped, or maybe you have a large advance from a PRO, you might say, I like getting 100% of my dollar with no commission or overhead taken off the top. It's an immediate 10% raise of my money. So it depends on the situation.
Amazing. There's a lot of questions about the MLC that I see we've answered in the chat, but one of the main ones is, can people outside of the US join the MLC, and who can join the MLC?
Sure. So the MLC is a mechanical licensing collective, meaning it's at the publisher level. So if you're a writer that has a publisher, your publisher joins. The same way they used to collect your mechanicals before the MLC, whether they use like the Harry Fox agency or a notice of intent. If you're a writer that keeps your own publishing, you are your own publisher and you can join the MLC. And it's for US royalties only. But if you're a foreigner that collects US royalties, then obviously you can join the MLC. And Chris Arend, who runs the MLC, does a fantastic job. And their website's very intuitive and helpful if you want to learn more about the MLC. But make sure, one of the great things about the MLC, the database is public. It's transparent. You can check your own songs to make sure that they're right. This is different than every other music database in the world. You can have a copy of it. And so take responsibility and ownership for your own careers. Ross does such a good job educating writers about the responsibility you have as a songwriter. Don't count on anyone else to make sure this is right. Make sure the MLC has your data right. Make sure that you collected the money that they owe you. They're there to pay you money. So make sure that you get it.
Yeah, on that note, and in another sort of anecdotal thing, and I know we're talking about specifics, but just things that I'm recognizing that are issues throughout this process. One of the things I said yesterday to you guys also when we were talking was, if you are not self-published and you are co-published and you have a deal with a publisher, remember that if you have 100% of your writer share and you have a percentage of the publishing, let's say it's a 50-50 co-pub, then you have 75% of the responsibility to push for your own copyrights. 75% of the responsibility should be on you trying to get sessions and on you trying to work with different artists and develop artists. 25% of it at most, in a way, should be responsible for the publisher to assist you in your 75%. Similarly, if you have a manager and you're a songwriter, they probably get 15 or 20%. You should be doing 80% of the work, 85% of the work. The manager is there to supplement and help you build your business. They manage your business. They probably manage other people's businesses as well, but you are responsible for yourself. No one else in this business is looking out for you the way you are. And so I just always want to remind the songwriter throughout their career how to be an entrepreneur, especially now. when you can help develop the next artist and you can be a part of their career, it's all part of your responsibility in your business to move things forward. It's not all of what we're talking about again is what happens when a song is successful. But in the meantime, as a songwriter, you can do many things that create a revenue stream for your business.
I will say, add to that though, that there is an organization that does support the whole songwriter in that pursuit to get to the hit, and that would be SONA. We definitely want to help the up and coming and middle class songwriters. You know, we're supporting that, what Ross is talking about, that work that we have to do as entrepreneurs and independent business owners, because that's not why we become songwriters, right? We don't become songwriters to run a business. We become songwriters because we can't do anything else. So we help. We really do want to like support those harder parts of it, and that's why we're here. That's, I think, our role. I want to get to another question because we're running out of time. Okay, if DSPs, it says it's dips, but that was a typo. If DSPs owe this percentage to both songwriters and publishers in total, why doesn't SONA, or I guess any other songwriter organization, have an independent seat at the CRB hearings?
I mean, I can answer that. So the CRB is a legal process like a trial, and anyone can file to be an interested party. What has happened over the years is that because SONA and other songwriter groups have worked so closely and well with NMPA, we litigate this as a team, but the songwriter groups then don't have to hire their own lawyers and pay that money out of pocket. Instead, that money can go toward advocacy. So for example, you know, I'll spend $30 million on a trial. Songwriter groups could do the same thing and have a second set of lawyers and also spend $30 million, but that doesn't make any sense. And so instead, we spend a lot of time coordinating, a lot of time talking. For example, Michelle and I got together very early in this process, and Michelle and SONA helped identify the witnesses that would appear at the trial as songwriters. And so even though SONA wasn't a party, the songwriters that were going to testify if we had a trial were going to be songwriters that SONA produced. That's the kind of partnership we have. And so I would not read anything into the fact that they don't hire their own lawyers and have their own people in the courtroom. That doesn't make sense for anyone. What makes sense is that we work collaboratively and that we do this as a team, which is how it's done. And that's why we've been so successful. So SONA has a right to comment on settlements. They have a right to offer opinion. We ask their opinion all the time, and we consider them partners. And I think it's wise to not try to duplicate the legal part of the process as a songwriter advocacy organization. And you know, but any group could file if they want to. It just doesn't seem that strategically that makes a lot of sense. And as long as we're working together cooperatively as partners, it's a better way to do it the way we do it. That's my opinion, but you know, Michelle, you can answer for yourself.
No, that has worked for us so far. I mean, you know, there is talk of songwriter groups participating. You know, when everyone sees how much skin we have in this game, that is, it does come down to like, wow, and NSAI, to be fair, NSAI is a songwriter organization that participates in the CRB. But those questions do arise of like,
yeah, and I'll give you another example. I mean, PROs litigate their rates sometimes in rate court under their consent decrees. ASCAP and BMI go to a federal judge in the Southern District of New York, and they have a trial over what their rates will be if they can't settle. When BMI or ASCAP litigate that case, there's no songwriter organization as a party to that litigation. They count on their PRO to go handle the legal part of the process to get the highest rates possible for songwriters and publishers. And that's what ASCAP and BMI do. They send in the best lawyers to fight for the highest rates when they go to rate court. Same thing that NMPA does in a CRB. So I think it's analogous to how that process has worked for I guess, you know, 80 years.
There's a really good question here. I think you answered it in the chat, but it is, I think for the bigger picture, it's from Clifton Road. These how will these historic decisions affect the next battleground and short form video platforms like TikTok and YouTube Shorts, which has become such an important, um, conversation for songwriters, right? We've been talking about this a lot. This is sort of the next frontier. So I see you answered it, but could you give your answer live as well?
Yeah, and I think it's a great question because it lets you take a quick step back. If you're in the business of writing songs, you don't often think about the world this way, but let me put it to you in this way. As a songwriter, you mostly make your money in 3 different ways. Mechanicals, which are regulated by law, and this court sets your rates. Public performance, which if you're an ASCAP or BMI writer, a federal judge decides the value of your songs under the consent decrees. Or synchronization. Synchronization, which simply means obviously marrying music to video, is not regulated by law. It's not regulated by consent decrees. It's a free market. And when I think of synchronization, you think of traditionally what sync meant. It was a single song for a single purpose. So a movie, a TV show, a commercial wanted to use one of your songs. You negotiated the rate. You used that one song and you got paid. That was a sync. But what has developed is one of the fastest growing income streams for songwriters are what I call mass synchronizations, which are platforms that have lots of songs, lots of video. They're not under the mechanical compulsory. They're not under the performance consent decree. They are a synchronization free market right. And we have been struggling over how we get paid from those platforms for a very long time. I litigated against YouTube in the first 3 years of that conversation. The problem with synchronizations is that even though we're in a free market, many of the companies that do them are protected by this law that's called the Digital Millennium Copyright Act, or the DMCA. And what the DMCA basically means is that if you're a platform where other people are putting up content on your platform, you're not responsible for the copyright infringement as long as you comply with certain responsibilities like taking things down. And so for a long time, we had battles with companies like YouTube over the DMCA and what we would get paid. That has matured into a market where a significant amount of revenue comes to us from mass synchronization. If you think about social media platforms, YouTube, Facebook, Instagram, Snapchat, TikTok, Twitch, Triller, all of these pay songwriters. But there's this tension over what our leverage is, because are they a DMCA company, or are we really in a negotiation over prices? I think that one of the next great challenges for our industry is getting proper value from mass synchronization sites like TikTok, like Facebook. It's not as simple as we'll just take the music down, because let me speak to the songwriter community about our biggest problem. Our number one problem of getting paid appropriately from these sites is you, the creatives, don't want us to take your music off the site. And so if a music publisher decides they're going to fight for higher rates, and their only tool to do that is to pull their music off the site, so they take down their music from Facebook or they take down their music from TikTok, the creative community goes batshit crazy, because individual creators want their music on that site because they're promoting a tour, or they're promoting a current record, or because their fan base, that's where they connect. And it's one of the hardest things for music publishers to figure out is, how do I increase what they get paid, but yet I can't really use the tool that would be most effective in doing that. And I think as a community, we need to have a much bigger conversation over what's the proper amount we get paid and what are we going to do about it. Because I can promise you, TikTok does not pay us enough. But yet, what if the only way to get paid enough was to be able to remove your music? And yet people don't want their music.
Yeah. No.
So it's a challenge. It's a battle. It's a significant.
This is sorry. One of the things that I think is a future part for if we're talking about things that we can fight for as a community, I'm convinced that when an artist can play a song on TikTok and then not release it, that it's, especially if they're a major label artist, that the major label is responsible for compensating the writers as it being either a released song and they already have to register it like that, or they need to find a way to compensate songwriters. And when I was saying that just because you release music doesn't mean you're entitled to make money from it, that's true in a technical sense. However, labels are releasing so much music so fast, and they are not paying for distribution or manufacturing of CDs or go back further. And it's not like they're doing shellac records. There's nothing that they're creating that is costing them any money. All they are right now are testing your songs on the market to see if they're worthy of putting more money behind them. To me, I think labels should be responsible for advancing a certain amount of mechanical royalties to the songwriters. So that way, if they're already going to be paying some of the songwriters, in the long term, they should be advancing that. If the song doesn't do well, that's the label's responsibility, not the songwriter's responsibility. I think that would help create a middle class of songwriters, and I've been fighting for that for a while. One of the things that we found out because of the Music Modernization Act and because of the MLC, we now have actual numbers of how we're getting paid. One of the things labels boasted for years is that they're getting 52% of streaming royalties. When it came down to it, when we went through the numbers, they were receiving 56.1% of streaming royalties. That may not seem like a lot, but that's about $3 billion. So that money was getting distributed amongst people who have masters and not amongst people who create the song. It's not necessarily that money is allocated for songwriters, so I can understand that. However, any label that says that they don't have the money to compensate songwriters for writing songs that they're releasing is full of shit. And it pisses me off because when they say things like, okay, let's say it was through a point structure like you would a mixing engineer or a producer, where that's how they would be able to define how they can recoup the advances. When they say, well, we don't do points for songwriters, remember that producers did not always get points from labels. They only started that in basically the 70s, and it became more ubiquitous after that. There were some stories of people getting it before that. Similarly, mixing engineers did not get points until the 2000s, and they still now get a point for the best. There's no reason why songwriters shouldn't be able to get a point on a record, get advances on that, and it's still not affecting how they're paying songwriters currently. Those are two separate issues, and in my opinion, labels are probably the next battleground a little bit for songwriters, and that's going to be hard for artists, and it's going to be hard for labels to come to terms with, but they could be helpful in creating a middle class of songwriters, and they use our talents, they use what we do. They should be compensating us for that. I'm done.
So thank you, Ross. That was, I mean, look, we do talk about this a lot, right? This is one of the many conversations we have in the internal, advocacy committee at SONA, and I know I've had with Ross and among other, sort of industry advocates for creators. So we have to go, but Louis Diller has had a few questions in the chat that we've left untouched because it goes to this idea of collective bargaining for songwriters, which is it's a thorny issue. On the one hand, we have been, Louis, we've talked about this. We have been sort of indelibly stamped by the National Labor Relations Board as independent contractors, and there are ownership issues that come with being an independent business owner, for our copyrights that we may not want to give up in lieu of in exchange for collective bargaining. So, but we have this conversation a lot, and I will say, you guys can weigh in on this, but I feel very strongly that some kind of collective bargaining rights are just so necessary just to get healthcare for songwriters. I think some kind of collective action we need to look, be working towards this. which is something we do at SONA. So we'll give another pitch for SONA. Again, we're the closest thing that songwriters have to a union, but we cannot collectively bargain in the United States. And I see all the questions. David, you might want to.
I do want to say something about this because I hear this a lot too. And it's a very common topic where people are frustrated and they look at other industries and they see some success when there are strong organizing principles involved or collective action by the creators themselves. And I'm not dismissive of those ideas at all, but I want to point out maybe the most important thing to consider before any writer concludes they want this. These other comparisons, and it's a great question, Louis, and you talk about the film and TV writers with the Writers Guild. When they write something, they don't own it. They write it for an employer that owns the intellectual property and they get paid. And they negotiate collectively over what they're going to get paid. Songwriters have this amazing experience of when they write a song, they own it. It's their copyright. And if they do a publishing deal, they agree what they're going to give away of that copyright. And so maybe it's 50%, maybe it's 25%, maybe it's none, and they're just going to let someone take a percentage to administer it, but it's the songwriter's copyright. If you had the option of having songwriters have the ability to act like the Writers Guild and get together and negotiate prices, but you no longer owned any of your copyrights, I don't think you would take that bargain.
Except that AV writers do.
Well, I mean, again, I don't think that's analogous for how AV writers do it, right? Because if you want to talk about works for hire, you can talk about it from that perspective, but I don't think you want to lose ownership of your copyright. So much of what a songwriter's existence is about is continuing payment from the copyrights they own, not a salary for what they get paid. And the other big difference is, remember, if the writer is signed to a publisher, the writers aren't collectively trying to bargain against the publisher over how much the publisher pays them, because the publisher and the writer, they're tied at the hip. They're getting paid the same on the same scale of what a third-party licensee is paying them. Writers don't really have the ability to collectively negotiate prices with the third-party licensee. And so it's not analogous to a situation of where a group of creatives are working for a corporate boss and they're getting paid by the corporate boss and they're negotiating the price over that. This is a different situation. Mm-hmm. So yes, we should find better ways to provide healthcare. Yes, we should find better ways to increase prices, but I don't think you want to trade ownership of copyright for collective bargaining if that's your choice.
What about dramatist guilds? Like, isn't that a similar thing where it's like they provide healthcare, they do, it's not the same sort of bargaining situation, but it is a group of people who do own their content, who still have structured, I mean, far fewer dramatists than there are songwriters, but as a member of the Dramatist Guild, they provide certain things that songwriters don't have. But it is actually kind of a similar thing to, I think, what Michelle's thinking in that way. It's not it's not necessarily used for the bargaining in the same way as it is to create a benefit program.
Yeah.
So maybe there are different levels, and this is a longer conversation, to what we could still provide as a group, where it's not necessarily about the bargaining for more money, when we have a number of groups that already take, I mean, PROs are taking a lot of money to do that on our behalf also. So it's like there are a number of people who are already at the table doing this. I'd rather us use the group of, use as many songwriters as we can so we can get group insurance that benefits us all. To me, that's still going to be, a benefit program for us would be massively helpful.
Yeah, and I think that's a different conversation than collective bargaining over prices of songs.
For sure.
I agree.
For sure. All right. Well, we have to wrap up. We've gone 10 minutes over. I do want to do a little bit of housekeeping, which is that we did record this. We are probably, David has already said that he will post those slides. Where are those going to be, David?
We're happy to put them on our website, or we're happy to share them with SONA or in the writers to have on your own website too.
great. And then we'll probably edit the video in some way and then post it somewhere, which we will let you know. Important to sign up with, if you're not a member of SONA, you can go to our website, wearesona.com, and join, or at very least get on our mailing list so that you know about these things. We're having our first ever annual membership address tomorrow morning at 9 a.m., where I will be making quite a few announcements about the future of SONA. So if you want to come to that, that is for members only, but you can join up right now if you want to be there. And it's going to be quick, from 9 to 9:30. And anything else? I want to thank everyone for coming. This has been really interesting. This is what we do. We get into the weeds. We think it's really important for songwriters to understand like where their money is coming from and to really know their business. To Ross's point, like we own our businesses and we need to be able to mind them. So thank you everybody for being here. Thank you, Ross. Thank you, David. BMAC was supposed to be Prophet from BMAC was supposed to be here. He couldn't make it because he had to fly. And if you're here from the Black Music Action Coalition, welcome and thank you for being here. Anything else? Did I miss anything?
No.
That was great, David. That was really interesting. And we'll definitely follow up with those slides. And thank you, everyone, so much for being here. Any questions?
Thank you guys. Bye.
Bye.
Thank you so much. Bye-bye.